Hello everyone. So now let's look into private limited company. Let's look into the advantages and disadvantages of choosing the private limited company to be the legal structure of your startup. We will look into it in the same four major classifications. The first one is the ease of formation and the compliances which are involved in it. The registration, incorporation and compliance aspects. The second one is on the liability part. What is the liability of the shareholders or the investors or the people who run the business? And the third one would be on the limitations or any restrictions that are available for a private limited company. And the fourth one will be the updation or upgradation to a public limited company. Okay, to start with, how do you incorporate a private limited company? Before which I would tell you the benefits of a private limited company. So when you're getting into a private limited company, it is called a company, whereas a proprietorship or a partnership is called a firm. A private limited and public limited are called the company. So to incorporate a private limited company, you should have minimum 2 directors and any number of shareholders. It can even be 1 shareholder or 2 shareholders or any number of shareholders. But the company should possess minimum 2 directors. Okay. Whereas in the previous discussions of proprietorship and partnership, the business was run and operated by the partners themselves, by the owners themselves. But with the private limited company, it will not be the same. The shareholders or the partners will be different, but the company will be run, operated and monitored by the directors of the business. The board of directors are responsible for the functioning of the business. Okay, so let's get into the first ease of incorporation or ease of running the business. So to incorporate or to start a private limited company, first, the directors of the company should acquire the digital signature. Once they get the digital signature, with the help of the digital signature, they would have to apply for a DIN number, which is called a Director Identification Number or DPIN. So through the digital identification number, through the Director Identification Number, they can apply in the Ministry of Corporate Affairs for the reservation of the name. The directors or the shareholders should arrive on a name for their business and the name approval should be sought at the Ministry of Corporate Affairs, which is the registrar of companies. So you would have to apply there with the necessary form and seek approval for the name. So your company name and what industry that it belongs to, and it would be followed by private limited. Okay. So once you get the name approval formalities, you would have to file your MOA and AOA, Memorandum of Association and Articles of Association. So what is this MOA and AOA? MOA, Memorandum of Association, is something where the business, what kind of a business the company is indulged in will be discussed. So what are all the types of trade or things that the company would be indulged in? So the board of directors or the managing director cannot act beyond the memorandum of association. So whatever tasks or whatever business points or classifications that are being defined in the MOA has to be fulfilled by the managing director. The managing director or the board of directors or nobody of the company can act above the MOA that is being declared at the time of incorporation. Yes, the MOA can be amended time to time with the help of a board resolution, but whatever contents or whatever declaration that has been given in the MOA can only be acted upon by the managing director or the board of directors. Nothing above that can be done. In case if anything above that is done, it is defined as supra virus. So that is invalid. So any act of a director or a managing director above the rights that has been defined in the MOA, then that is a void one, which is none. Okay. What is Articles of Association? Articles of Association is where who are all going to be the directors of the business and who are all going to be the shareholders of the business, and what is the share percentage that everyone carries, and what would be the share returns or dividend that will be paid to the shareholders, and things related to those, which is things related to the ownership of the business and operation of the business would be discussed in detail in the articles of association. So after the name approval, the directors has to pass a board resolution, and the directors has to file the MOA and AOA with the registrar of companies. So after you file the MOA and AOA with the registrar of companies, and after declaring the percentage of shares for the shareholders, you will be provided with the incorporation certificate of the business, after which you can start to commence your business. After you receive your incorporation certificate, you would have to apply for your PAN number of the business. So incorporation and formation of the business, when it comes to incorporation and formation of the business, you would have to apply for a digital signature, then DIN, director identification number. Then you would have to seek for the name approval. After you get the name approval, you would have to go with the filing of MOA and AOA. So that is how the incorporation process takes place. So after incorporation, how do we run the business? How easy it is to run and operate the business is the question here. Normally, when it comes to a partnership or a proprietorship or limited liability partnership, the partners or the owners will run the business. So here it is not the case. The business will be run by the board of directors and the managing director, the chairman of the company. But shareholders will not be involved in the operational aspects of the business. So the company or the private limited business will function as a separate entity, and the shareholders will be third persons to the business. The shareholders' involvement in the business will be only when the profit and loss are concerned, and they will not be involved in the operational aspects of the business. So ease of running the businesses depends upon the directors that are being appointed in the business. And when it comes to compliances, every quarter compulsorily or mandatorily the directors has to file their eKYC. The reason why government has imposed this eKYC filing mandatory is to avoid shell companies. I will discuss in detail about shell companies in a different video, but shell companies is where the black money is being parked, the illegal money from other countries are being parked, and that money is being used for illegal activity. So this, to arrest that aspects, the Ministry of Corporate Affairs and the Registrar of Companies have declared it mandatorily to file eKYC every quarter for every single director of the business. Okay, so when it comes to compliance aspects, you would have to file your eKYC every quarter, and you would have to file your balance sheet and income tax return as which has been defined in the proprietorship or partnership or whatever business it is all about. Apart from this, you would have to conduct the board meeting. So you would have to conduct a board meeting once in a particular period of time, and that particular period of time would also be discussed in the MOA. So based on the declaration that is mentioned in the MOA, the board of directors meeting would be held. So the general board of directors meeting is called the general body meeting, where it may happen every 3 months or every 6 months. So when it is a small sized business, then usually people conduct it once in a year to review the performance of the board of directors, to review the performance of the business, whether the business is traveling in the right track, whether the business is making profit in the trade. If it is going to be a huge company, then the board of directors would assemble at least once in a quarter to review the performance of the business. Okay, so when it comes to the compliance aspects, board meetings are mandatory to review the business proceedings. And so ease of incorporation and ease of running the business, when those two aspects come into picture, I've explained the incorporation procedures, and to run the business, the board meetings would decide what to do and then proceed with the things. So any new contract or any new business or any new acquisitions or any new sale that the business indulges in that case, a special resolution has to be passed by the board of directors. So when there is a proposal for the business, it is not one person who takes a decision on the proposal. The proposal would be put forth into the board of directors, and all the board of directors would review the proposal and they would come up with their own pros and cons in the proposal. Based on the pros and cons of every single director of the board of directors, the final decision will be taken by the managing director. A regular voting process would happen, and based on the voting, the final decision would happen. So this would help the business to succeed. This would help the business to avoid taking wrong decisions. When a lot of like-minded people get together as board of directors and take a decision, definitely at least 90% of the decisions would be supportive for the business. So that is why when it comes to a private limited company, every single decision, every single major decision, not all the minor decisions, in the course of regular business, managing director will make the decisions. But when it comes to a new contract or a bigger contract, or when it comes to selling of any immovable property of the business, in those cases, it is mandatory that the managing director should conduct a board meeting and all the directors should have approved the transaction. Either all the directors should have approved or majority of the directors should approve the transaction. Only based on that, the chairman will pass orders. So the operational aspects of the private limited company is completely dependent on the board of directors and not on the shareholders or the real owners of the business. Real owners will be concerned only on the profit and loss aspects of the business, because they would hold the shares in the business, and the shares profit and loss would directly imply on the owners or the shareholders. Other than that, everyday regular tasks or regular operational intervention will not be there from the shareholders. Okay. So when it comes to liability aspects, the second important aspect is liability. So when it comes to liability aspects, how much is the shareholders liable and how much is the directors liable? Liability is the very important aspect when it comes to a private limited company, because the shareholders will be liable only for the profit and loss of the business, not in anything other than that. In case if the business indulges in a wrong trade or an illegal act or a mischievous act, and for example, let's say the business has given a check for so and so amount to somebody and did not honor the check. So in that case, the person who is affected because of that would sue the business under the Negotiable Instruments Act. In that case, if the business is found to have committed the mistake, then the managing director and the other directors will be considered as the defaulters, not the shareholders, because the directors and managing directors are the people who run the business. So in the operational aspects, any liability arises, that would impact only the directors and managing director of the business. When it comes to profit and loss, the directors will not be liable for the same. In case if the director is both the shareholder and the director, then obviously there would be impact on him as well. But when profit and loss in general aspects comes into picture, only the shareholders will go through the struggle. For example, if the company makes so and so profit, then that would be divided among the shareholders. That would be divided based on the terms that has been defined in the MOA which we previously signed. So maybe in the MOA it might have declared that for every single share you will get only 10% or 5% of the profit as your dividend, and the remaining amount will be again invested in the betterment of the company. The MOA could have been declared in that particular pattern. So in that cases also, the shareholders will receive profits based on the terms that have been defined in the MOA and AOA of the business. Okay. So when it comes to financial liability, yes, the shareholders would get affected. When it comes to any kind of other liability that arises due to operational aspects, the directors and the managing director of the company will be liable for the same. Okay. So in terms of liability, I guess we are a little clear on that aspect. And third aspect when it comes to limitation or restriction part. So there is no limitation and no restrictions when it comes to a private limited company in functioning. The private limited company can have any number of directors, any number of shareholders, and yes, the private limited company can apply for any kind of state government and central government licenses, and they can proceed forward with their business. Only thing is, the directors are restricted to function according to the rules termed in the memorandum of association. They cannot go beyond the terms or rules that have been defined in the memorandum of association. And apart from this, the fourth aspect is updation. How would you update to a public limited company? So private limited company can be migrated to a public limited company based on their business requirement. In case the company requires more funds to be invested, and if the company has or the board of directors have decided to release public offering, to release shares for public offering, in that case the board of directors would pass a special resolution. They would approach a credit rating agencies and get their business audited, and based on the audit conducted by the credit rating agencies, a proper credit rating would be provided for the private limited company, and based on that credit rating, the public offering share values for the business will be decided. So based on this, private limited companies can be upgraded to a public limited companies. So these are the four major classifications which are important to consider when you decide whether you would want to go into a private limited company. Here again, let me tell you, if your business is going to be a startup, and if there is only 2 or 3 directors who are going to get involved in that aspect, so I would suggest you to go with an LLP. And when you progress further, and when you need additional people to come in who build strategies for you, things like that, then you can go ahead and opt for a private limited company. So in a private limited company, the liability quotient is the key factor. The shareholders or the investors will not be liable for any kind of a mischievous act that the board of directors or the managing director indulges in. So apart from that, a private limited company is considered to be a separate entity, or a separate, it is considered to be a virtual person. So the private limited company can possess title for any kind of an immovable property. So in other words, a private limited company is nothing but a virtual person. So let me summarize again. So when it comes to compliances and operational aspects of the business, operation of the business is handled only by the managing director and the board of directors, not by the shareholders. And in terms of compliance aspects are concerned, private limited company should conduct regular board meetings to decide on the further progress of the business and to review the previous and past records of the business. And also the private limited company should file balance sheet and income tax returns every year and with the Ministry of Corporate Affairs. And it is very much mandatory that a private limited company should have a auditor appointed. The auditor appointment shall be for 3 years or 5 years or whatever tenure that they prescribe. But an auditor appointment for a private limited is mandatory. So these are the costs that a startup can cut if in their very initial or niche stage of incorporation. So when they plan to expand or when they plan to scale up their business, yes, they can very well upgrade to a private limited company from a partnership or a limited liability partnership. So I would suggest to take wise decisions as founders and do not waste your money or an energy in unnecessary compliances which you are not required to proceed with. The term of the directors of the business is also defined in the MOA of the company, where a director can be in unlimited number of years term, or the directors can be appointed for shorter terms. It can be for 3 years or 1 year or 5 year, whatever the board of directors at that point of time decide can be defined. Directors can be disqualified if they do not file their EKYC every 3 months, I mean every quarter. And directors can be disqualified if they do not attend the general body meetings and regular board resolutions, if they do not attend the general body meetings. Directors can be terminated by a board resolution passed by the majority of the directors as well. And Directors are eligible for a monthly or a yearly remuneration as defined by the MOA of the business. So this is a short explanation or a brief compassion about private limited company. So I would suggest the startup founders to make your decision wise. Thank you so much for your time.